Yeah. All right, guys. Hopefully, this will be our last session on legal jurisprudence and legal theory. Let me just. Yeah, come in, please. Shut the door fully when you come in. All right. What have we covered here? We have covered the science element. Karl Popper and the definition of science has been covered, and we've covered civil law systems versus common law. This we have covered. Okay, inquisitorial. Just tell me where because between section A and B, I've we came to hierarchy of courts. Yes, come in, please. So we came to the hierarchy of courts. क्या है प्रॉब्लम है क्या ये दरवाजे को उनको बोलिए आने के लिए और आवाज ना करें. Okay, guys, so we started on stare decisis. Did we? We didn't start. Okay, so we just kind of stopped at hierarchy of courts. Okay, fine. Let's do this then. Let me also go and open the Glanville Williams article. This is the other mic, right? Anyway, let this work initially. At least let my mic work. This can come later. I was just worried about the red light, so I don't know whether it's going to conk out or not. Okay. All right, guys. So let's just open this and let's continue now with stare decisis. So we didn't start this topic at all, right? Okay. So this is one of the most. Thanks. Yeah, this one you can just fix later. Okay. So stare decisis is one of the most important aspects of what we call the common law jurisdictions, which is give me some examples. Did I tell you about some examples of common law jurisdictions? We didn't? Yeah, okay. So all the English colonies, okay, former Australia, New Zealand. Yeah, I mentioned it, I think, when I discussed common law versus civil law jurisdictions. We discussed, okay, all the Australia, India, Canada, US, these are all referred to as common law jurisdictions. And I think I also referred to why, strictly speaking, these are actually now mixed jurisdictions. We mentioned that as well, because a pure common law jurisdiction means that there is no statutory law at all, which means there's no parliament making any laws, okay? All you have to go by are the previous decisions of judges on similar cases. That's a pure common law system. That's how English law developed, okay? But it's a very rich body of law. Even if you just look at the pure body of common law before the parliament started making laws, it's still a very rich and very comprehensive set of laws, okay? That's why it's taken hold in so many countries around the world. So stare decisis, or the doctrine of precedent, is a very important aspect of this common law system, okay? So what it essentially means is, here, as you can see here, the translation of the Latin word, of the Latin expression. Yes. To stand by precedents and not to disturb. So basically, don't disturb what's already been settled. That's the idea, okay? So what you will see here is the overarching theme of consistency, okay? Because, and you can once again connect it. The idea, you can see why this is conducive to consistency, okay? Yeah. So briefly, what the doctrine of precedent means is that when you have a particular case that has been decided in a given way. Yes. This 10 minutes grace is very disruptive, actually. It essentially means that the class starts about 10 minutes late. Okay, there is a brief, okay. Yeah, you can you can understand this a little bit better from this particular paragraph in the Glanville Williams article. Is the font size big enough for everyone? Yes. At the back? Okay. So you can see here essentially what we say by the doctrine of judicial precedent. What do we mean? Is suppose that in a certain case you have facts A and B, and fact A is deemed to be immaterial. Okay, so only B and C are deemed to be material by the court. Okay, and I presume you guys have read this article by now. Okay, so you have to understand what is meant by a material fact. That is a fact. What is a fact that has legal salience? Okay, so in a car accident, if the driver was drunk, that is a material fact. But if the driver was wearing a red shirt, that's not a material fact. Okay, that fact does not have legal salience. Okay, so here what do they mean? So essentially we have in this case facts B and C are material. Okay, if you have a case like this, and then the court reaches conclusion X. Okay, in this particular case where B and C are material, what the doctrine of precedence is telling you essentially is that in any future case where B and C are the material facts, okay, which means essentially the fact is the case is very similar on facts as far as the material facts are concerned. No case is going to be identical on all the facts, but material facts, it's similar, then the court must decide it in the same way as it is decided the earlier case. Okay, so the conclusion here also must be X. Okay, is this clear? So can you see how this is conducive to consistency? Okay, so if the court is consistent in deciding cases, okay, of all flavors, then do you think it will create a more predictable system for the citizens and the people who live in the country? Yeah, or businesses and normal individuals. So that is the whole idea. So you can connect this as to if you think about why do we need this doctrine, why do we need judges to be consistent. So one of the ways you can connect it is to this need for a legal system. You can then go back to the purpose of the legal system, and you can think about, okay, why if you have a legal system that is conducive to a stable and predictable kind of environment, then is that going to be good for business or bad for business? It should be good for business because it will help people to plan, okay, and it will also be fairer because people will have some idea as to how even in your individual lives you can conduct yourself better. But mainly it has a very big impact on the business environment, okay, because if you have a stable and predictable environment, then businesses can plan long term. Okay, obviously economic uncertainty does not go away, but at least regulatory uncertainty, if you have some confidence about regulations and taxes and things like that. Yeah. Again, I've lost the internet connection. Lalitha, I think we have to tell these guys again why I've lost that connection. 1 minute. There seems to be a problem with the internet today. Huh? Just give this to them. Might have to message these guys. There seems to be a problem with Lalitha. Just 1 sec. Because I just connected to this network and I lost it, so there is no connection here. I'll just work on my. I'll use my own geo. But we need to just message these guys, the IT guys, because even in the office our PDM 201 is not coming. Okay. So I'll just work with this. Okay, so is this clear, guys, that the idea of consistency and a stable and predictable business environment, especially the regulatory environment, taxes, it helps businesses to plan better. Okay, so in fact you can see a real life case study here where one of the reasons why, if you see there's a dramatic shift. Yeah, I hope my alarm is working. Oh, she's out. So Kanika's out. Why did my alarm never go off? Alarm, I tested the alarm and it's not gone off. Okay, so this alarm is a little slow. This alarm is a little slow. Okay. So the aliens are working, but the aliens are a little late. Okay, that's the only problem. So anyway, Kanika, right? Kanika is going to be out today, so you're going to be present but absent. Okay, so let's do the attendance. I'm just going to freeze the. Okay, so stare decisis, doctrine of judicial precedent. Okay, so you can see the value of this. So what was I talking about? I was talking about the stable and predictable environment for business. So you can actually connect this from this theory to a real world event which has happened. If you see, there was a dramatic improvement in the economy after Donald Trump took office in the US, okay? And there was a dramatic jump in consumer confidence, business confidence, small business confidence. This is because there is a very dramatic contrast between the regulatory philosophies of Obama and Trump, okay? So Obama is more of you won't get attendance, so it's up to you. You want to attend, or you want to just hang out somewhere. Okay. There's a very dramatic contrast between Obama's regulatory philosophy and Trump's. Okay, so Trump is a free marketer, so he believes in limited government. His belief is that the role of government is a very typically capitalist view. Okay, that the role of government is to get out of the way and let private enterprise do its thing. Whereas Obama's view is a much more socialistic view of the economy. As you know, he did introduce socialized medicine. Okay, so all this kind of, and his view was that businesses essentially needs to be heavily regulated. Okay, with excessive consumer protections and things like that. So there was a tremendous regulatory drive within the Obama administration, which actually severely dampened business confidence in the U.S. because farmers were losing confidence. You know how the EPA might come after them for all kinds of regulatory breaches. So it was a very dramatic difference, and so you can see firsthand from a recent example in the real world. You can even give this example if discussion comes up. That how there was a dramatic jump in business confidence when Trump came in. Essentially, not even that the tax cuts had passed, because the tax cuts took about a year to pass. Okay, but even before the tax cuts were passed, because he, as the head of the executive branch, was able to dramatically cut regulations. In fact, Trump's view, and in India also, we can take a lesson from this, because he's clearly had a dramatically positive impact on the U.S. economy. Okay, which is always a good thing. And his policy was that, I think for every regulation that his administration has introduced, they have cut 22 regulations. Okay, I think Mr. Modi also did something like this, but it was not so drastic. I think he also had a similar idea. But in the US, Trump has been actually very, very aggressive in cutting regulation. That was one of his main promises, that I will drastically cut regulation. And so this obviously creates a lot more, and businesses get to realize that there's a business-friendly administration in charge. So then the laws are likely to be pro-business. So this creates a big jump this leads to a big jump in business confidence. Okay, so we have deviated quite a bit from the legal aspect of the judicial precedent, but you need to be able to study everything from a multidisciplinary point of view. Okay, it's not sufficient. You don't need to be locked in a silo that we only look at the law. You can see the connection between the law and the real world. And so the objective here, one of the important ways, you won't get attendance. So it's your choice how you want to use your time. So you can do whatever you guys. So I won't repeat this every time. So obviously, if I tell you won't get attendance, means you can either come or you can go and hang out in the library or canteen or wherever. Okay. So what was I saying? So this connects to the important idea that one of the important roles of a legal system. If you think about what is the role of a legal system, so one of the important roles of a legal system is to create a stable and predictable environment so that businesses can prosper. Okay, there is a business uncertainty. Business optimism is revived, and this is one of the, as I said, everything down at the end of the day, everything boils down to economics. If a country can't get its economy in order, then everything falls apart. Okay, you can see another very good test case in the real world today, which is, are you guys following the situation in Venezuela?
Yes.
You know what is going on. There's a lot of unrest. People are like eating dogs and stuff like that. There's no food. It's a total disaster. And do you know that Venezuela has larger proven oil reserves than Saudi Arabia? The highest proven oil reserves in Venezuela are actually in Venezuela. And there is total mismanagement. Okay, it's a socialist government, and they have totally messed up the economy. Can you imagine a country like that with so much oil wealth, and it's a total disaster now? There's chaos, there's fighting and looting on the streets, people are eating dogs, there's no food in the supermarkets. It's a total disaster. If you want to see a test case of how, what socialism does, you can go to Venezuela. Okay, you can go and check. Maybe don't go there, but just follow the situation. In fact, if you remember when Donald Trump gave his first speech at the United Nations, he made the statement that the reason that Venezuela is in such a bad shape today is not because socialism wasn't implemented properly, but it's because socialism was implemented properly. And that's why you have this situation. So anyway, again, you can see here that, okay, to some extent, you can sense that I'm more of a free marketer. I don't believe in socialism. But then I'm not going to require you to subscribe to because these are political economic philosophies, okay? So if you want to be a socialist, you can still subscribe to it. You need to be aware of the two different philosophies. You need to be aware of the facts, and you need to be able to defend your position, okay? So if you're going to believe in socialism, you need to be able to defend your position. That's all that is required, okay? So, but at the same time, it's important for you. The reason I tell you all this and reason I give you some of my views is This will give you, because you're much younger than me, so your views are not so well formed maybe, and you're not able to articulate it so well. So when you look at my views, so I'm like a radical free marketer, okay? So when you see my views, what you see, not because you have to follow my views, that's not why I'm telling you my views or giving you my views. By looking at the way I speak and the whole worldview, you can see what a well articulated and consistent set of views looks like. Okay, so you can have the same type of views on the other side of the socialist argument. Okay, but when you look at my views, you'll get to see what a well articulated and a consistent set of views looks like on one side of the spectrum. Okay, so the role of the legal system is important role is in fostering a stable and predictable environment, and hence you can connect this to the idea of stare decisis. Hence we have a requirement that we don't want to disturb previous, and we want to be consistent in the way we decide cases. Okay, so this is broadly the idea of stare decisis. Now to understand, there are two other terms that we need to learn. Okay, so vertical versus horizontal stare decisis. What does this mean? You can connect this once again to the hierarchy of courts. You are already aware that everyone has a broad idea that you have the district courts, then you have the high courts, and then you have the Supreme Court. So there is a hierarchy, and everyone knows what a hierarchy is. Okay, so when we say vertical stare decisis, this is all that it means. Okay. Okay. Power of higher courts to bind lower courts. Okay, if you look at, there is an article in our Constitution 141 which actually expressly lays this out. Okay, this is just because this is the title of the section and this is the section itself. It's the same, that the law so it's mentioned in the Constitution. Okay, in case it wasn't obvious, that is mentioned in the Constitution that the Supreme Court decisions will be binding on all courts within India. Okay, so if there is any kind of a case which is decided by the Supreme Court on a particular matter, and you're arguing a similar case in any high court in the country or a district court, you can cite this as a precedent. You can cite the Supreme Court case as a precedent, and it will be binding on the lower court. Okay, because of Article 141, it will be binding on the lower court. And so here we will say there are actually two sets of terms we need to learn. One is vertical stare decisis versus horizontal. And then we will also learn about binding precedents versus persuasive precedents. Okay, so we just use this term here. That I gave you an example where you take a decision from the Supreme Court and you're arguing a case in a district court or a high court, and then you cite that Supreme Court decision, which happens to be the same as your the material facts are the same as in your case. So you cite that Supreme Court case as a binding as a precedent. Okay. So it will be a case of vertical stare decisis because this higher court is binding the lower court, and it will also be a case of what we call binding precedent. Okay, because the lower court is bound to follow it. Okay, that's what is meant by binding precedent. Okay, some people sometimes use the word bounded. I am bounded. Please don't say that. You're bound, but there's no such thing as bounded. Okay, I'm bound by my promise. Okay, so okay. So these are the two terms additional terms that we need to know. There are four terms actually: vertical versus horizontal, and binding versus persuasive. Okay, so let's come to that a little bit, and let's understand what is horizontal stare decisis. Okay, so horizontal, you can read this for yourself. I'm not going to repeat everything. Okay, so generally we if you look at this discussion, you can read up in detail on your own later on. But the general principle is this, that in the high courts, for instance, if you say in the high courts you have different strength, you have this concept of a bench strength. You understand what a bench is, right? So in the law we refer to the judges as the bench, and then the lawyers are the bar. Okay, and so as far as the benches are concerned, you can actually have a single judge bench, or you can sometimes have a 2-judge bench. Okay, or sometimes a 3-judge bench in the high court. Okay, and then you can have a full bench also. Okay, of the High Court. So that's quite rare actually in India.
Generally happens in international court when I've seen UN when there was this case in for India and Pakistan. So there are some 5-6 judges sitting.
Yeah. So International Court of Justice is different. They always sit on. I think I'm not sure that whether it's always, but I have never seen them sitting in a smaller strength. They're always sitting on the full bench. Okay, the full bench of the ICJ sits. Okay, so the ICJ essentially is a jurisdiction. You can opt for that jurisdiction if two countries want to, like this Kulbhushan Yadav case is being argued there. Okay, so both countries have agreed to accept the jurisdiction of the ICJ, and therefore we have taken the case there. Okay, So that court is slightly different. They sit always on the full bench. Okay, even the U.S. Supreme Court, when it always sits on a full bench, what is called en banc in the U.S. Okay, but in India we don't sit on the full bench on a full bench. It never sits like that actually. And then sometimes you have these what is called the Constitution bench for constitutional issues, which is 5 judges, sometimes 9 judges. Okay, sometimes 11 judges. Okay, but full bench in the Supreme Court in India is very rare. Okay. So you have the concept of bench strength. Now the concept of horizontal stare decisis essentially is, it is also connected to bench strength. Broadly what it means is that the same court is bound by its previous decisions. So if you're arguing in the Calcutta High Court before a single judge, and you have a previous decision, say from several years ago, of a single judge of the Calcutta High Court, and the material facts are the same. So you can actually, you can actually say to the single judge in your case that you are bound, you can actually pressurize the judge. You can use that precedent. So even in horizontal stare decisis, we say that a court is bound by its own previous decisions. Okay, unless you can show that there's something seriously wrong with the previous decision. In general, by default, you understand what default means? Yes. The default rule. The default rule is that the court is bound by its own previous decision. So in the Calcutta High Court, if you have a single judge and you have a previous decision of a single judge or 2 judges or 3 judges of the Calcutta High Court, you can actually pressurize that judge in your case and say, look at this case, it was decided by this court and these are the material facts, the same facts as in my case, so therefore I should also get the same decision. Okay, you can actually put pressure and they're actually bound to do it unless they can show that there's something wrong. If they feel there's something wrong, and then they have to essentially, they can't even overrule a single judge feels there's something wrong with the previous single judge decision. He will have to refer that to the Chief Justice so that the Chief Justice can constitute a larger bench. So you get the basic principle that if you want to overrule, you need a higher strength. You need a larger bench essentially. So a 3-judge bench can overrule a decision of a single judge. Okay. So even they will try to honor it unless they feel that there's something wrong. So if you have a single judge Calcutta High Court decision and then you're arguing before a 3-judge bench, you cite a precedent, and if they don't, unless they can show that there's something wrong, they are also required to follow it because it's the same High Court. But if they feel there's something wrong, they themselves can overrule because there's a larger bench. Okay, so you can see the connection here. I mean, how the rule operates. That if it's 3, I mean, you need a larger bench to overrule. Yes.
Sir, are interstate courts?
Let's try and use the mics, guys. Can pass it to him and let's have the mics so that. Yeah. Yeah. Not working. You should be able to sense that it's not working. Yeah.
Sir, are interstate courts on the same level bound to follow the judgments of the other court, or is it on the same?
I got your point. Okay, very good question. So this leads us to our other question, which is the other discussion, which is on persuasive precedents. Binding precedent, you already understand. Okay, if it's a Supreme Court decision, everybody's bound. Okay, in general also courts are bound by their own decisions under horizontal stare decisis. But the question that Rajan is asking is about states, courts in different states. So if you're arguing a case before the Madras High Court and you have a decision of the Delhi High Court on a similar point, okay, exactly similar to your case, I mean material facts are similar, then you can cite that precedent before the Madras High Court, but the Madras High Court is not bound to follow it. Okay, so in this case we say that this precedent is persuasive. As far as the Madras High Court is concerned, the Delhi High Court decision on the same point is a persuasive precedent but not a binding precedent. Okay, but a persuasive precedent doesn't mean that it will not be followed, because it is still possible that the Madras High Court may be very impressed by the logic and the reasoning of the Delhi High Court decision, and they may decide to rule in the same way. So it is still possible. So even if you have a persuasive precedent, if you think the reasoning is very good, it is still worth citing it because it might end up being followed. Okay, because judges have to give decisions, although they have a lot of discretion. There is the other aspect of judgments, is, as you will see when you do your judgments, that they don't say that okay, this guy wins. They have to give detailed reasons for why they're ruling in a particular way. Okay, these are called speaking orders. Okay, normally when you give any kind of orders, even if it's a shorter order, you have to give what is called a speaking order. Okay, which means your order should give the reasons for coming to that conclusion. Okay, so if a judge issues an order which is not a speaking order, that is considered to be bad, essentially, bad form. All right. So these two terms, you understand what is judicial precedent. Now we can talk about vertical or horizontal stare decisis. These terms are clear now, okay? And you can read this article by this extract from Subbarao's judgment, okay? And so we have binding precedents versus persuasive precedents. And these are all terms that you need to know, okay? All right. Now this brings us to the ratio decidendi, okay? If you see what we are saying in the doctrine of precedent in stare decisis, we are saying is that previous decisions have to be followed, okay? But if you look at a judgment, if you look at any judgment, it's a big judgment. And the question might arise, now which part of this judgment should I follow, okay? So this is where we bring in the idea of ratio decidendi, and the answer essentially is going to be that it's only the ratio decidendi of the case that needs to be followed, okay? So not the other parts, okay? And so ratio, this is the plural, rationes is the plural, okay? And there is something we'll define which is called obiter dictum. This does not need to be followed. And here again the plural is this. So the broad answer is that when you are following previous judgments under the rule of stare decisis, it is the ratio decidendi of previous judgment that needs to be followed, okay? And that's why you will see that as it's mentioned in the Glanville-Williams article also, that understanding the ratio of a case is very important, okay? And in many cases you will find even seasoned lawyers don't really understand the ratio of cases that they are citing. So it's quite difficult actually to grasp the ratio of a case. I wouldn't say it's difficult, but you just have to be alert, and you have to be able to understand the reasoning properly. So so it's not something that is easy, and it's an art. It's not there's not a science. It's not a formula like you put H2O and you get water. So you always do that. You can do it with your eyes closed. So it's not like that. It's something that requires a lot of judgment, okay? And the more you read judgments, the better your skill improves as far as detecting the ratio of a case is concerned. Okay, so when you do the judgments that we do further down in the course, further on in the course, one of the types of questions you'll get is what is the ratio of this case, okay? That itself is going to be difficult for you to figure out, okay? All right, so let's understand ratio decidendi and obiter dictum. Okay, here's our article, okay? Let's, so you have some idea about the ratio. Now what he's saying is, now this is the part about the doctrine of precedent, okay? Okay, so it has a discussion about the, so you guys are all familiar with this case now. You've read this case, Wilkinson versus Downton. You can already see in this case, just to note as an aside here, there are two claims that Mrs. Wilkinson has made, okay? That is, one is on the railway fares, okay, that she spent money on, and the second is obviously the main part of the damages that she's claiming is for nervous shock for that £100, okay? So the first part, you can see here how the first part is decided very easily by the judge, and you can see here one of the other advantages of the doctrine of stare decisis is that it helps judges to reach decisions more quickly, okay? You don't have to reinvent the wheel because there's already a previous decision on similar points. Okay, so what he says here, he uses this precedent of Pasley versus Freeman, okay, which is a case where, so he's saying, when he's saying this is what he means, that clearly within the decision of Pasley versus Freeman means that this matter of the railway fares, okay, is covered by the logic of the decision in Pasley versus Freeman. So I don't need to reinvent the wheel and go through the decision again. And so this first part is, you can see here an application of stare decisis, okay, to decide some of the issues in the case. All right, I just want to go back. So he's worked on the ratio decidendi in stages, okay? He's talking about how it is to be extracted. So there's a lot of levels of abstraction. Yeah, this is the part essentially, okay? So finally, what is the ratio that he's extracting from this particular case, okay? That he has done because Downton has done something with intent to affect the plaintiff in body or mind, and there is an adverse effect. Okay, so whatever damage he has caused, he is liable to pay to compensate for that. Okay, so this is the ratio. So one of the things that you would note in this ratio, so I haven't gone through the whole article, okay, it will take us too much time, but if you have any questions about any part of the article, you can ask me. Okay, So essentially this is the ratio. So you can see one thing about the ratio is that it is extracted or stated in a fairly general way, at a high level of abstraction. Okay, it's in a fairly general way, and it's not something that is very, very specific to the facts of the case. You can still connect it to the facts of the case, but the ratio has to be stated as a general principle. Okay, so if somebody has committed murder and he is being sentenced to death because he is being first held liable for the crime of murder. Okay, so we say that he intentionally caused the death of another person through his actions. Okay, so that is how murder is defined in the statute, and so we say that what his actions match the definitions in the statute, the ingredients of the statute. So therefore, he is held to be guilty of murder. Okay, and so we basically, obviously, in that particular fact, obviously there is one person, Mr. A, who has murdered Mr. Y. Okay, so all these facts are also bound into the decision that the court gives. Okay, the court does not give a general decision. The court obviously says that Mr. X is guilty because Mr. A is guilty because he has murdered Mr. Y. Okay, and this is why we think he has murdered, because his actions were intentional and it caused the death of this person, etc. So the point is, from the specific facts of the case, because the court decision will always be on the specific facts of the case, but from there you have to extract a general principle. So the idea is, remember, ratio decidendi means reason for deciding. Okay, so you have to go behind the mind of the judge, into the mind of the judge, and understand what was his logic for arriving at this kind of decision. That's all that the ratio is. Okay, so what are the general principles he's using to arrive at this decision? Okay, so that is what you have to look at, reason for deciding. So what are the general principles he has applied to arrive at the conclusion in this case? Okay, so the general principles connected to the facts of the case, and then the conclusion that is reached on those principles. So that's essentially your ratio decidendi. Is this clear? We'll have a better idea as we go on. Okay, Khushbu, you're clear about? Yeah.
Yeah, actually, sir.
Try to use the mic, although you don't need it on the first bench, but let's get into the habit. Everybody should get used to the mic. Yeah. I hope you're not nervous about speaking on the mic.
No.
Okay, many people are nervous. They want to avoid the mic. Yes.
So like you said that if there are two similar
Closer. Make sure the voice comes through the mic. You need to be able to sense that. Yes.
if there are two similar cases and there are similar material facts, you said that the judge is bound by the decision of passing.
Not always. If it's a persuasive precedent, he's not bound. You have to remember that, because you made a statement in a very general way. The judge is bound only if there is vertical stare decisis operating, in which case a higher court is binding him. Okay, but if it's because your statement was very general, that's why I'm qualifying your statement. It's not, your statement will not be true if the precedent is a persuasive precedent. That means you're taking a Delhi High Court decision to a Calcutta High Court case. So the Calcutta High Court is not bound to follow the decision of the Delhi High Court. So that's a persuasive precedent. Okay, so yeah, you said bound, so I just wanted to qualify that.
Yeah.
Okay,
but,
yeah.
If there is no persuasive possible, so is the judge bound to take that pressure on him to pass a similar statement just because it was mentioned in the similar case?
Yes, that's the whole meaning of stare decisis. So if the judge doesn't like that case, so we'll come to these points of distinguishing. Okay, we'll come to these points of distinguishing where you can see some part of some answer to your question. But by and large, what I would say is that if the judge cannot show, if the judge cannot, we'll see what distinguishing is. So if the judge cannot distinguish that case in any way, okay, or he cannot show that there is some kind of there appears to be something wrong with the previous decision, because courts do overturn decisions. Okay, even our Supreme Court has overturned decisions like stood for 10 years. Like in arbitration, we had a famous case called Bhatia International versus Bulk Trading, which stood, it's a Supreme Court decision which stood for 10 years. But then a similar decision came up before the Supreme Court, and a 3-judge bench essentially said that, we feel there's something wrong with this case, with this decision. So they referred it to the Chief Justice. And then the Chief Justice convened a larger bench, and they eventually ended up overruling Bhatia International versus Bulk Trading, which had a case which stood for 10 years. Okay, so it's a Supreme Court case. So unless the judge, so the two answer, yes, a broad answer is yes, he is always bound, unless it's a persuasive precedent, A. B, unless he can distinguish the case in some way, or C, unless he can show that there's something wrong, there seems to be something wrong or grossly wrong with the decision. Okay, like in the US you had decisions like Dred Scott and where you had the US Supreme Court saying that slaves are not human, slaves cannot become citizens, etc. And that decision was overturned, okay, eventually. So unless you can show that there's something wrong, so with these three qualifiers, otherwise he is bound. Okay, that's how the system works. Okay, all right. So you have some idea now about what ratio decidendi is? Okay, read on further, and then let's come to these important points of distinguishing. Okay, there are two types of distinguishing here. All right. Oh, sorry. So first is ratio decidendi, and as it also is mentioned in the Glanville-Williams case, I'm not going to spend too much time on this. That is obiter dictum. So everything that is, you can pretty much say that everything that the court says in its judgment, okay, everything it says in its judgment, which is not essential to reaching the conclusion in the case. Okay, so the court may opine on a host of other issues. Okay, but you just have to take a very parsimonious. You want to understand what is parsimonious? Parsimonious means stingy. You know what stingy is? Stingy, you don't know. Okay. Stingy, no, not mean. Stingy means essentially not willing to spend anything. Okay. So being very, keeping it very minimal. Okay. So you have to take only the minimum. So essentially, when you're trying to extract the ratio decidendi, okay, ratio decidendi, you have to take only the bare minimum logic that is required to reach the conclusion. Okay, only the bare minimum logic that is required to reach the conclusion in the case. Other than everything else can be regarded as extraneous. Okay, just the bare minimum logic. Okay, that should be the idea. So essentially, the court discusses all kinds of things. One of the reasons it engages in all these discussions is that the advocates cite a lot of cases. Okay, as you can see, because as you can anticipate, because we have this in the common law jurisdictions, we have an adversarial system. Okay, so the two advocates will argue against each other in front of the court and against each other's positions. And one of the things they're going to do, because stare decisis applies, so one of the things that every advocate will try to do, he will try to cite a bunch of cases. He will try to cite a lot of precedents which according to him are in his favor. Okay, and so therefore he will try to pressure the judge to rule according to those precedents and decide in his favor. And the other guy on the other side is also doing the same thing. Okay, so there's a bunch of, in every decision that is being arrived at by the court would typically have to discuss many precedents which are being cited by both the sides. So the good rule of form for judges is that if a advocate is citing a case, the judge should discuss the case. Okay, even if he thinks the case is not applicable, he should bring up the case. Okay, and he should then say that for A, B, C, D reasons, I think this case is not applicable. But he needs to bring up the case and knock it off. Okay, he needs to check the box and knock off all the cases that they have mentioned. Okay, so in the course of one of the ways that obiter dicta are generated in the case, in a particular judgment, is because the judge often has to discuss all these cases, and many of these cases another thing that you'll notice about advocates is many of the precedents that are being cited are quite obviously not relevant. Oh, they're just citing it for the sake of citing. But because of that, the judge has to deal with it. So in the course of doing that, he generates a lot of statements which are essentially in the nature of obiter, because they are not required to reach the conclusion in the case. Okay, so everything else, so you can just look at it as kind of like muscle versus fat. Okay, so the ratio decidendi is the muscle in the case, and everything else is fat. Okay, so all the obiter dictum is fat, and the muscle is just the bare minimum logic required to reach the conclusion in the case. Okay, as you read right now, we're doing it in a very theoretical way. When you start looking at actual cases, you have this one case here, Wilkinson versus Downton. But as you look at more actual cases, you'll get a better flavor for it. Okay, all right. So this is basically what obiter. So obiter does not need to be sort of followed. Okay. So one of the things that lawyers will try to do is that when the other side's lawyer is actually trying to say that in this particular, I'm citing this case, and this particular case, the ratio of this particular case is so in ABCD, that other guy will try to say that no, this ABCD is not the ratio of that case, that is just obiter in that case, because he knows that obiter doesn't have to be followed, so he'll try to brand it as obiter. Okay, so this argument also goes on. So another argument you have is, pass the mic back to Rajan. So another type of argument that you have in cases is these two are lawyers, and sometimes the court also is not clear about whether something constitutes the ratio of the case or actually just constitutes obiter in that case. So what is the ratio of this case? You'll see in the Supreme Court also there'll be up and down arguments about what exactly is the ratio of this case. Okay,
So as you said that defendant judge can turn down the
There's no such thing as a defendant judge. You said defendant judge.
lawyer, sorry.
Yeah, defendant's lawyer, yeah.
Yeah, can turn down the facts that have been cited as the ratio decidendi by the plaintiff lawyer. So
Facts are never ratio as such. Logic, yeah, okay, whatever that, yeah.
if the lawyer cites the exact section or the exact law or the exact case on which the decision has been made, so how can the other judge turn down?
No, judge, you mean advocate, the lawyer, yeah. No, he's not turning down as such. Obviously about the statute you can never say that, but the statute is never the ratio decidendi. The ratio decidendi of a case is basically that the case lays down a type of principle. Like you can see in this Glanville-Williams article that Wilkinson versus Downton was the first case, as he says here. This is a case of first impressions. Okay, so it's a case of first impression means there was no precedent in the English common law for that kind of offense. Okay, what he did. So there is a principle that is being laid down in this Wilkinson versus Downton case, which is that a person who intentionally does some act to affect the other person in body or mind and causes an adverse effect will be liable for those consequences. So that's a first principle. So this is how a ratio decidendi would be stated. So this is a principle. So this typically a ratio decidendi will not refer to, it may refer to it, but it will not be just a particular statute or anything like that. The statute obviously you can't contest because it's written down. Okay, what you would contest is the interpretation of the statute, which you can see later on. Okay, so is this clear? Does it answer your question? Okay. All right. So arbiter dictum does not have to be followed. Only the ratio decidendi has to be followed. So you can see the connection between these three concepts: the hierarchy of courts, then the doctrine of stare decisis, because vertical and binding stare decisis. Okay, and then also horizontal, also connected somewhat to the hierarchy at one particular level only. And then the question of ratio decidendi, because if you're going to follow the previous judgment, then the question arises, what part of the previous judgment? And the answer is only the ratio of the previous judgment. This is clear? Okay. Now let's come to this very important aspect, distinguishing. Try to understand this concept. It's, I'm sure many practicing lawyers don't understand distinguishing. Even in our LLB course, it was not taught, it was not really discussed in the class. Okay, although thankfully it was there in the reading. Okay, so distinguishing, you have two types. First we're going to apply the labels and then we will discuss those two types. So we have either non-restrictive or restrictive distinguishing. Okay. So non-restrictive he is also referred to as genuine distinguishing. Okay, so let's do the non-restrictive part. First, the non-restrictive part is the distinguishing based on facts, on material facts. Okay, so if you go back to the let's try and use this article for understanding this. Okay. Yeah. Okay. So here you see non-restrictive distinguishing essentially. All right. So this is what it is. Okay. So non-restrictive, you can remember it also as distinguishing based on facts. Okay. So all you try to show is that the case that is, let's say case A is being cited as a precedent, okay, and your case is case B, and you try to show that in case B there is some difference of material fact. Okay, maybe that the driver was not drunk in case B. Okay, in case A the driver was drunk. Okay, and maybe in case A there was there was somebody actually got killed. Okay, whereas maybe in case B he just kind of rammed into a tree or something. So the quality of damage, so there's the material difference, no person was actually hurt. Okay, these kinds of things. So the non-restrictive distinguishing is the more is easier to do and is more common, which is where you have to try and show that there is a material difference, there's a difference in material facts between the two cases. So whatever the other party is citing as a precedent, you would try to argue that, well, that cannot be applicable in this case because there is a material fact in this case which was not present in the other case, or vice versa. Okay, so distinguishing based on material facts. You try to show that the material facts of your case are different from the material facts of the case that is being cited as a precedent. Okay, that is non-restrictive distinguishing. Now, restrictive distinguishing is essentially this. Okay, let me give you an example. So, in restrictive distinguishing is actually this is the part. Okay, it is called restrictive distinguishing. Okay, that you are actually cutting down the ratio decidendi of a case. Okay, a rule laid down in a particular case. If you feel that the rule is too wide, obviously only a senior court can do this. Okay, or the junior court then would have to follow the process by referring it to the Chief Justice and a larger bench. But essentially the idea of restrictive distinguishing is you feel that the ratio of the previous case that was even maybe explicitly laid down in that case, but that ratio was unnecessarily wide. Okay, so essentially here you can see, I'm just trying to find that part where he mentions yeah. Okay. So let me just give you the theoretical, I'll just put it down here. Okay. Let's say I'm just going to enter into this. Okay. In the precedent, okay, we have material facts were A, B, and C. Okay, A, B, and C were the actual material facts, but the court actually considered only B and C. So the idea is, theoretically I explained, then I'll give you an example. So in the case of the precedent and in the current case, okay, and in the current case, which is your case, the material facts are only B and C. All right. So on the face of it, it appears that this is a valid precedent because the earlier court only took cognizance of. You understand this expression? Took cognizance. Took cognizance means I recognized it. Okay. I took cognizance of the fact that Gulati came in late. That means I registered that fact in my mind. Okay. It did not. That means I'm not unaware of it. I have taken cognizance of the fact. Okay. So this is what it means. Okay. This is what how the language is used. So in the precedent that is being cited, the court took cognizance of only two material facts, B and C. Okay. And in your case, in the current case also, the material facts are B and C. And so therefore the precedent is being cited. Okay. But if you want to restrictively distinguish this, what the court will say or what the lawyer will say is that actually the court in the previous case missed out a material fact A, which was also present in case A, which should have been taken cognizance of by the court, but it did not. Okay, so the actual ratio that has been laid down in the case in the precedent should only apply to cases where all three, A, B, C, are all material facts. But you see, in my case, only B and C are material facts. Okay, so the court essentially, you have to say that the court earlier made a mistake. Okay, because it failed to recognize the material fact and laid down a rule which is too narrow. Obviously, you can see that a rule based on only B and C is wider, not too narrow, too wide. Too wide. Can you see that a rule based on only B and C is wider than a rule based on A, B, and C? Yes. Because in all cases, A may not occur along with B and C, right? So this is basically the theory of restrictive distinguishing. So you try to argue that the precedent that is being cited actually is based on the on a failure of the apparent ratio of that case is based on the failure of the court to recognize a material fact, okay, which was present in that case. So A was present as a material fact, but the court failed to recognize it. Okay, and you see in my case, the material facts are only B and C. So how can you match a case in which the material facts are A, B, and C to my case where the material facts are only B and C? Are you following the logic? Okay, now let me give you an example. It will become a little bit better. Not a very good example, but anyway. So let's say that the students of DSB go to NUS for a business program, okay? And one of them is carrying a hookah, and one of these guys are caught in the hostel in NUS smoking a hookah, which is against the hostel regulations. Okay, so a bunch of people are caught in the hostel, and let's assume they were all guys. Okay, although we know that need not always be the case, but let's assume they're all guys. Okay, and let's also assume that only, let's say, just like biologically men can't have babies, let's say biologically, let's say as a rule, girls cannot smoke hookahs. Okay, let's assume for the sake of argument. Okay, I'll show you what the rule is. So now what happens is, let's say that a judge, let's put this in the case of a judge. So a judge rules that therefore DSB students should not be allowed to come to NUS. Okay, all no DSB students should be allowed to come to NUS because they are violating hostel regulations by smoking hookahs. Okay, so this is the rule that is laid down by the judge. Okay, is this clear? Are you following the logic so far? So based on the transgression. Okay, now you could argue that this, if this ratio is sought to be applied, okay, to further batches, future batches of DSB students, now you can argue that you can try to restrictively distinguish this ruling by saying that, look, girls do not smoke hookahs, and the people who are caught there were all male students. So if you have a rule which says no DSB student can come, that means you're ruling out all girls and boys. Okay, so what you would argue is that this rule was formulated in a very wide manner. It basically forbade all DSB students, girls and boys. But because only boys smoke hookahs, okay, and only the boys were smoking at that time, therefore this rule should have been formulated more narrowly to exclude only male DSB students. Okay, are you following the logic? So don't do this if you go there. So this is an example of, not a good example, but it's an example of what is called restrictive distinguishing. You try to show that the previous rule was unnecessarily wide and was not warranted by the material facts of the case. So in this case, if you give the analogy to A, B and C, then the judge at NUS failed to take into account the material fact that all the people who violated the rule were all boys, okay, and the fact that only boys smoke hookahs, that he forgot to take, which we have artificially assumed, which we know is not true, right? Okay, so right, so now you understood what is meant by by restrictive distinguishing. Okay, so these are very important, so please make sure you give him the mic.
So you told that we assume the boys only. Sir,
not you told, you said.
You said.
Either you say you told me, or you told us, or you say you said.
So you said that only boys smoke hookah, and you said that we assume. So in real life cases, can also assumptions be considered as facts?
No. I'm just giving you this artificial example because I wanted to come up with an example. I don't have a better example from an actual case. Okay, I do actually have that, but I don't have the facts on that case. There is an income tax case which I can show you again later, which is an example of restrictive distinguishing. But I artificially created this situation. In real life, obviously, you can't make assumptions. In real life, if it is true that girls can also smoke hookahs, then obviously you can't make that assumption in the court. That will not work. I have artificially made this assumption here. Yeah. Okay. All right. Okay. So what were we saying here? Okay, so distinguishing, very important. Make sure you understand this concept because again, I'm sure many lawyers who are practicing may not be able to understand this distinction properly. Okay, so restrictive and non-restrictive distinguishing. That pretty much, I think, does it for us. I've told you not to worry about sub silentio because it's a little more complicated concept. Okay, yeah, so as he is importantly mentioned, then there's a discussion of arbiter dicta. Distinguishing, the ability to distinguish a case is an important tool for a lawyer, okay, because in a common law jurisdiction, because everything is based, judicial precedents have a huge role to play in decisions, okay, very big role to play. So therefore the ability to distinguish cases, okay, is very important because that's like it can make the difference between winning or losing a case because judges give a lot of importance to precedents. All right, okay, so this is done. I think pretty much we are done with this particular case, with this particular article. So let's go back to this. And so distinguishing the two types, okay, so I've referred you for this, you will refer to the article by Glanville Williams, okay. All right, now just quickly try to finish up. I have artificially cut down this particular module syllabus because we are losing too much time on these introductory materials. I want to get on to the cases. Okay, so briefly I'll just spend some time on this case and you should be familiar with these two terms. The two terms are FILAC and IRAC. In the US, some of the people in the US refer to Iraq as Iraq, and Iran they say Iran, okay. So IRAC and FILAC, okay. So FILAC is a term that is used in Australian law schools and IRAC is used in the US law schools. So we should be familiar with all that is missing from IRAC is that there should be a F in the beginning. Okay, so it's actually, you can read it in brackets, although in the US they don't use the word FIRAC, they use IRAC, but they have left out the facts part. You can always add that, and so then you can compare it with FILAC. Okay, all that is, so everything is the same, only thing is difference is L and R. Okay, so IRAC is IRAC, so all these are all the same. Okay, and only thing is L is for legal principles in the Australian framework, and R is for rules, which is the same thing. It's basically two different terms for the same thing. Okay, you will consider the legal principles and rules. Okay, so I see a lot of people taking notes. I hope you guys are aware, you can always take notes. You have access to all these notes. Okay, so then if you want to take additional notes, that's good actually. In a way, it may help you to remember. In any case, I've told you that you should, when you study, you should actually make your own notes from these notes, and maybe listening to the audio, listening to the, looking at, watching the video or whatever. Okay, so this is just a framework that we use. It might help you to understand the cases. Most of you are reading judgments for the first time. So first is facts. Okay, it may seem a little bit silly to talk about facts because it's so simple, but in many cases you'll notice that the facts are also quite complex. So it's important to have a good handle on the facts. As a famous judge in India, I think Krishna Iyer said that first get your facts right, then you can twist them as much as you want. Okay, so many times lawyers don't even have the facts right. So that is another problem. So especially the ones who are very busy, they are covering so many cases that they don't have time to read the brief properly. Okay, so facts, then issues, we understand what issues are. Okay, by the way, the British pronunciation of this word is actually issues. Okay, whereas in the US and India we mostly say issue with the SH. Okay, but actually the classical British pronunciation is issues. There is no H in that. Okay, so anyway, so you could argue that if you're going to speak French, you might as well speak like the people in Paris, not like the people in Mozambique, right? Because that's a French colony. So you should technically say only issues. There's a guy who speaks very well, from your on your English communication skills. I might refer you to this guy, and you can check on YouTube for this guy called Nigel Farage. Have you know about Brexit, right? So Nigel Farage is he was the head of the UK Independence Party, and he was one of the moving forces behind the Leave vote in Brexit, but convincing people to leave. So if you listen to Nigel Farage, he's a very impressive speaker. So you can just Google Nigel Farage on YouTube and listen to all his speeches. He speaks very well, and you'll notice that these Britishers, they always say issues. Okay, they don't say issues. Okay. So and the issues here, and then the legal principles. Okay, so here when you're discussing the issues in the case, there are two. You can discuss it at two levels. Okay, we'll come to this when we take a particular case, but I'm just giving a broad outline here. One is the issues based on the facts of the case itself. Okay, that did this person violate section 300 of the IPC. Okay. Or did this person's actions attract the provisions of section 300 of IPC? Now that's a very specific statement, and you will actually mention the name of the person also. That is how that statement of the issue is very clear from the way the court writes it. In most cases, the court will actually write down the issue in the case in that specific manner. Okay, so and typically when it comes up on appeal, etc. Okay, it will be written explicitly by the court. What you have to develop a sense for is, what is the statement of the issue on a more general level? You have to go to a more abstract level, because then you can connect it directly to the ratio decidendi that will come. Okay, so we'll come to this example, but you have to be aware that the issue has to be stated on two levels ideally in your mind. That the abstract level also has to be stated and then connected to the ratio decidendi. Obviously, legal principles, same as rules in the US system. Okay, so what are the principles that apply? Statutory or common law statements of law that are relevant. Okay, statutory means is referring to acts like Contract Act, Transfer of Property Act. Okay, statutory refers to the acts made by Parliament, and common law principles means we are referring to the judgments. Okay, previous judgments on the same kind of point. Okay, and then obviously first, so at one stage you'll see this in the judgments. The courts typically follow this kind of framework. Okay, without stating it. And they will lay out all the provisions of law that are relevant, statutory provisions, then the cases that are applicable to this particular situation, and then they will apply those principles to the facts of the case. Okay, so pretty much the conclusion, the last part. Okay, this has not been bulleted. Okay, Okay, so the conclusion pretty much is actually redundant, but it's there in the framework, so I've kept it. Okay, because once you know the legal principles and the application, the conclusion is apparent. Okay, but here the conclusion is explicitly stated by the court, so we just keep it as a separate part of the discussion. Okay, so this is a framework that you can use. We'll see the framework more when we look at the individual cases. Okay, so here you can see, you can just, there's a video that I've given. This is a good video actually. You can watch this video to better understand the IRAC framework. Okay, all right, and this last part I'm just trying to end this module over here artificially because it's getting too long. Okay, so the last point that I want to make, this will directly come into the contract law section, is there's a difference between these terms. Okay, acts, rules, and regulations. Okay, so in the legal system, you'll hear references to what is called the Bare Act. Sometimes when you go to the shop to buy a particular act, he'll ask you whether you want Bare Act. Okay, what does Bare Act means? Bare Act just means that the act only without the rules and regulations. Okay, so this is basically the term that you have to be aware of. Now, rules are made by no, this is not made by the legislature. The rules are made by the executive branch. And regulations, this reg stands for regulations. Okay, so do you know what the difference between rules and regulations is? This also is useful to be aware of. Okay, so rules are made by the part of the executive branch that is closer to the the prime minister or the head of the executive branch, and regulations are made by the also by the executive branch, but a particular part of the executive branch which is this is also by the executive branch. Statutory bodies, what we call statutory bodies. Okay, not correctly spelled. So an example of a statutory body is ICA is also a statutory body, you could say that, but a better example in this case would be SEBI, RBI. Okay, so SEBI, RBI, they have been set up as the securities regulator and the banking regulator. So what we say, notice that RBI rules, when we refer to, actually they are called RBI regulations. Okay, now Ministry of Finance, when it's making rules, those are called rules. Okay, the Ministry of Finance is much closer to the the head of the executive branch. Okay, so that's how you understand the difference between rules, regulations, and acts. Some people are quite sloppy about the use of these terms, but that's not, they should be, you need to be careful. You should have the right idea. Okay, so acts are made by Parliament. Rules are made by the part of the executive branch that is closer to the head of the executive branch. So Income Tax Act, rules are made by CBDT, that is Central Board of Direct Taxes. Okay, so they are much closer to the head of their part really of the functioning government. Okay, and then SEBI, for instance, will make regulations. Okay, SEBI regulations, because SEBI is slightly further away from the head of the executive branch. Okay, slightly, although they are actually bound to follow the overall directions they are under the executive branch also. Okay, so these we call statutory bodies. Example, SEBI. Okay, and when you're reading laws, okay, if you look at various laws, you'll see that when we are referring to rules, okay. Okay, so this part we'll discuss later. There is a particular way to refer to rules and a particular way to refer to regulations. This we'll discuss later. Okay, this I don't know, this program is still around, you can check it. There was a very good program on corporate law called The Firm. Okay, it was on CNBC TV 18, but this girl has actually left, so I don't know if this program is still on. She has now gone to Bloomberg TV. So on Bloomberg you'll have a program, Bloomberg TV, you'll see that even on Bloomberg Quint there's a section on law. Okay, so try to follow that. Try to make the connection continuously between the world of business and the world of law, because you have to get comfortable with this idea of multidisciplinary approaches. Okay, that is something else that is expected from MBAs, that you should be comfortable with a multidisciplinary approach. Okay, because you're not just a computer programmer who's come out with a BTech, okay, and is just a hardcore programmer. You have a broader training, so that is one of the special skills that people expect, along with communication skills. And you saw that, remember that job skills survey that I showed you? So strategic thinking. So strategic thinking partly is very connected to the idea of being able to connect to look at things from a multidisciplinary perspective. Okay, that is also important from developing strategic thinking skills. So always be comfortable with this, looking at things from a multidisciplinary perspective. Okay, so just check for this and just check for the Bloomberg thing. So this ends our particular module here. Okay, we have some amount of time, so we are going to now get on to contract law. Okay. Okay, all right. So let's quickly start on contract law here. This has to be maybe a little smaller. Okay, so you might have found the theory unit in unit 1 a little bit boring, but let me just clarify. Those of you who found it boring, what I would say to you is you're not entitled to find it boring because you're not here to be entertained. Boring only applies when you're going to see a movie. Okay, you expect to be entertained and you find it boring. So you're not even entitled to be bored because you're here to learn. You're not here to be entertained. Okay. So whatever we are telling you now, this is your good luck or bad luck that you're taught by us. So you are subject to our decisions on what is relevant. Okay, because you don't really know that much about the area. So whatever we decide is relevant, we teach you, and then you have to take that as a given, and then you have to just master those concepts. Okay, so if you think it's getting boring, it's not even relevant, right? That I'm finding it boring. It's not relevant because you're not here to be entertained. Like people sometimes say, I don't go to the gym because I find it boring. I prefer to play tennis. But even if you go to the gym, it's like brushing your teeth. You're not there to be entertained. It's a job you need to do. So you don't think of it as boring or entertaining. Okay, like you never say that brushing my teeth is boring. Obviously it's boring, but then you don't stop brushing your teeth because it's boring. Okay guys, so these are various links I've given you. These are easy to access. They are not behind a paywall. But only thing what you should do is if you're actually involved in a case, refer to this link. Okay, the income tax website, these are maintained by Taxman. All the acts are not there, but many of them are there. If you're actually involved in litigation, some of these other links I've given you, they're easy to refer to, but they're not always updated with all the latest amendments. Okay, so the more reliable versions of the acts are here. Okay, these are all most of them are there, but obviously many are not there. Okay, one of the good things that this government has done is they have actually, I think they managed to successfully do that. They basically repealed a whole bunch of antiquated laws which were not being applied. So they managed to get rid of that. That is part of the overall deregulatory effort, but it needs to go further. Okay, so you can see that the US being much bigger than us, much more prosperous than us, they are actually much more aggressive on cutting regulation than we are. And we are sitting here, and not cutting aggressively enough. Actually, we have much higher, longer to go than those guys. So and their tax rates are already now lower than us. Their corporate tax rates are already lower than us. And they are now no longer taxing on this latest tax reform that happened. India and the US are the only two big economies that I know of which tax their residents on global income. So here what's happening is Infosys being headquartered in India, okay, whatever they earn in Japan, they're having to pay tax on that also here. Okay, now the US used to also have the same system, like Apple used to have to pay tax on its earnings in South Korea, UK, everywhere. Okay, but only if they brought it back. Okay, only that's why they used to keep a lot of money outside. But now they've changed even that. See how aggressive now, how competitive the US has become. Now in the US, this will cause a drift. A lot of companies will now go and incorporate in the US because it's such a massive market, and now they are not being taxed. So Samsung US will no longer have to pay tax on its income in Korea and all those places. Okay, if a company, Samsung is, let's say, headquartered in the US, if they move their headquarters there, now they do now Microsoft being headquartered in the US no longer has to pay income tax on its income in Microsoft Japan, because now they have moved to what is called a territorial system. Now the US has a territorial system, so they no longer tax companies on their global income, whereas we are still taxing them on their global income. So in many ways our tax system is less competitive, our regulations are more onerous than an economy which is much bigger than us, much more prosperous than us. Anyway, these are all things you have to be aware of, not connected to law as such, so explicitly, but these are all things that matter in the real world. All right, guys, let's start the contract law module. Okay, so essentially some of these terms that you might hear in the in a discussion of capitalism, etc., and also is this concept of freedom of contract. Okay, so in a free capitalist society, one of the things that those societies which are marked by less regulation, the principle that the governments try to follow is that they give the citizens the freedom of contract, which means two people can come to any kind of contract. Okay, so the government generally will not try to interfere with what is called, this is considered a very important principle in a capitalist system, that you respect the freedom of contract. You don't try and go and tell them you can't do this kind of contract, can't do this kind of contract. Okay, so obviously one of the things that freedom of contract requires is that there should be mutual clarity on terms of the contract. We'll see more about this later. Now, just a brief idea on contracts, okay, which is broadly we say that contracts are formed by offer and acceptance. Okay, this is a broad, just to get a broad idea. We'll look at the technical definitions later. So once the offer is accepted, you have a contract which is formed. Okay, so this is basically just to give you an overview. Okay, but you will find that in the Indian Contract Act there is no explicit mention like this, that this is formed by offer and acceptance. Where you find it is in, basically we have this in the Sale of Goods Act. Okay, if you look at this section 4, section 5, okay, section 5(1). Okay, so a Sale of Goods Act is dealing with particular types of contracts for the sales of goods. Okay, so this particular Sale of Goods Act used to be earlier part of the Contract Act. So the Indian Contract Act was actually a huge piece of legislation. It's one of the most really well written piece of legislation, because we haven't had to change it much. It was written in 1872 by the British, and essentially it embodied many of the principles of the English common law of contracts. So the advantage in the UK, there is still no Contract Act. So all UK contract cases are all decided based on common law principles. Okay, but what we have as an advantage here in India is that, so as to avoid disputes about, because one of the problems in the common law system is you can have arguments about what is the ratio of the case. So two people are arguing about what is the ratio of the case. So if you had what we got in 1872 was a codified version of the English common law of contracts, because all the principles came from there, and we essentially, our parliament codified it. Okay, the British codified it into the Indian Contract Act. So it's very useful actually. So and in it initially we had even the Partnership Act, what the Partnership Act today, that also was part of the Indian Contract Act, because partnership is based on a agreement between partners. Okay, so that is also a form of contract, a special type of contract. So it was also, Partnership Act was also earlier part of the Contract Act, and then the Sale of Goods Act was also part of the Contract Act. Okay, so these are all different types of contracts. Okay, so you have contracts in general, then you have particular types of contracts. So sale of goods is, contracts for sale of goods, contracts for the sale of a particular type of contract. So here what it says is, so this point is, the point is we're trying to make here is that a contract for the sale of goods is a contract, which means it's a particular type of contract. Okay, and so what they say here in section 5(1), you can see, is made by an offer to buy or sell goods for a price and the acceptance of such offer. So you can see one example of this very basic idea of contract, which is offer and acceptance. That is actually written down in the Sale of Goods Act. Okay, so let's go back to the Indian Contract Act and look at, so you can look at this, if you go here, we are going to just refer to this one actually. I've just taken out this, so there are some typos here. Is this font big enough for you, Kanika, at the back? Okay, so these are all, now we are not going to cover all the sections obviously because it's very big. We are going to cover most of the first part, chapter 1 also, and chapter 2, and essentially we're going to end at chapter 2. Okay, so up to about 30 sections. All this stuff for contingent contracts, okay, like insurance and things like that, this we are not going to cover because we don't have the time. We need to go on to other modules. Okay, so let's look at, there are some typos here obviously. This is a typo. Okay, you guys have to be aware of this. Yeah, there is not violable contracts, it's actually voidable.
Voidable, yeah.
This is voidable contracts. Okay, so it's a typo. Okay, so we'll just use this. Let's try and go on to, okay, so let's look at this. This is, you have the short title which comes in initially, etc. Okay, most of the acts you have a interpretation clause, okay, or a definitions clause in section 2. Okay, look at this definition clause here. Okay, just try to eyeball this definition here. But we are going to actually study this. You can study it from either side, but I have got a. Is this too small now? Okay, so just try to read this briefly here, and don't spend too much time on it. You see the arrangement of this interpretation clause, okay? Or what I'm going to do is, I'm going to actually go directly to my version of this, and then you can study this at home on your own so that we can save time, okay? So you see that it is laid out in the contract, it's laid out in a particular way. You can see this when one person signifies. So what are they mentioning in A? In clause A, what are they saying? Proposal. In clause A, they're defining a proposal, okay? Then in clause B, they're defining a promise. Then the clause C is promisee, clause D is consideration. Okay, clause D is consideration. So these are all concepts that we have to be clear about. Then here you have agreement. What is an agreement? Okay, and then reciprocal promises. What is a void agreement? Okay, never say void contract. Okay, agreement and an agreement, and what is a contract? So finally you have a contract. Okay, and agreement, and here then you have voidable contract. Okay, which is the last one, which is a contract which becomes void. And here this I is actually a voidable contract. This part, there is no typo here. So this is the arrangement here. Now I have done it in a slightly different way, which I think is more logical in terms of the arrangement. Okay, so let's try and look at, and you can study it either way. Okay, you can just study it whatever way you want. You can either study from my arrangement, or you can study from the act, whatever suits you, whatever you find more easier to understand, whatever you find easier to understand. Okay, so what I've done is I've done it this way. I've gone backwards actually, and I've tried to keep it more logical. Okay, keep the flow. Okay, so first we start with what is a contract. Okay, so we say that an agreement that is enforceable by law is a contract. Okay, so that's the definition of a contract. All right. Okay, so here if you go to this. This is too big actually. You can't see the other parts. Okay, this is already in your thing. So this is how we should divide it. Okay, the coloring is not proper. It should be, you have to make it even smaller than this. Oh my god, it's 67. Okay, so it should actually go up to here, and if we have this as, let's say, brown covering this. Okay, so you have two types of agreements. You have either you have a void agreements. I want to center this. Either we have a void agreement, and let's make this something, maybe it's let's give it a, okay, so you have obviously maybe you can't read it now because of this deep red color. I just wanted to give it a red color because it's void, but that is not helping us. Okay, now you can read it. Okay, so the first classification is essentially you have two types of agreements. You have all agreements, overall class of agreements. Some of them will be enforceable by law, so they are called contracts, and those which are not are called void agreements. Okay, so I didn't come to that part. I immediately went into all right, so actually now the problem is I have reduced that size. Now this one also has gone down. In this way I think Firefox is a little smarter. Firefox does it tab by tab, but Chrome is doing it for all the tabs. Okay, or maybe it's a settings thing. Okay guys, so logically trying to follow, maybe I shouldn't have gone to the framework first. I should have gone through this logic. Okay, so first is what is a contract? A contract is an agreement enforceable by law. Okay, now the question then will arise, what is an agreement? Because you're just defining contract in terms of agreement, so now you have to define agreement. Okay, it's like these, you've seen these babushka dolls in Russia. There you take out one doll and then the same thing, you get the same doll in a smaller size, so one after the other, that kind of logic. Okay, so what is an agreement? Now agreement is essentially every set of promises, okay, forming every promise and set of promises, okay, forming the consideration for each other is an agreement. Okay, that is the definition of an agreement. Okay, so now again you have a problem because you have defined agreement. In defining agreement you have introduced words like promise, you have introduced a word like consideration. two new words have been introduced, so now you have to define these. Okay. Now, obviously, there's another term also which you can see together, which is every promise and set of promises forming the consideration for each other. These are also called reciprocal promises. You understand what reciprocal is? Two-way, basically. Two-way with some idea of equivalence. Okay? Because if you go and again you go into your international trade, if you connect it, this is a big word now. Especially Trump is using it a lot when he's trying to change the trade agreements. He's always saying what? He's saying, I want reciprocity, because the US tariffs are much lower and tariffs in other countries, even Japan, EU, China, are much higher. Even India, he has also complained about. So he's saying, I want free trade, but I want reciprocity. So if we have 2% tariffs, you also better have something low down there, okay? So don't have like 15-20% tariffs on our products. So reciprocity is another word that is coming up in international trade negotiations. Okay, so reciprocal promises. So we had defined agreement in terms of promises and consideration. Okay, so and then the other term is obviously every promise and set of promise forming the consideration for each other. These are also promises which form the consideration for each other are called reciprocal promises. Okay, so this is another term. Now, okay, so now we have to define promises, we have to define consideration. Okay, so the next one defines promise. So promise says, what is promise? Simply promise is a proposal that has been accepted. Once a proposal has been accepted, okay, that becomes a promise. Okay, so we'll come back to consideration later, but at this point we go on. Again, the problem with promise is you have defined promise with respect to proposal. So now you have to go and define proposal. Okay, so proposal is a little more complicated, okay, because it is worded in legalese, but essentially it's a promise to do, also to not to do. This you have to get comfortable with in the law generally, okay, unless there's a exception made specifically. In generally, when we say act, we also include omissions. Okay, that means omitting to do something, okay, forgetting to set the alarm, okay, that's an omission. That is also going to be considered as an act. So an act in the law, it generally concludes omission. So when we say promising to do something, it includes the promise not to do something. Okay, abstain from doing something. You understand what abstain is?
Yes.
Okay, okay,
So,
yeah.
so is there a difference between abstain from doing and omitting to do? What is the difference?
See, if you say abstain from doing something and omitting to doing something, there is generally no difference. The sense only from a contextual point, you might say that abstain from doing something might be a result of a previous plan or promise, whereas omitting to do something has the sense of forgetting to do it. Yeah, so that is the loose sense, but generally there is no real difference. Okay, so proposal, what is, now we have defined it in terms of proposal. Proposal means now I promise to do certain things or not to do certain things. Okay, I promise not to invoke the guarantee. The company has given the bank a guarantee, the bank promises not to invoke the guarantee, and this becomes part of an agreement. Okay, all right, so now that other class has been released early, so they're making a noise. Okay, now we come back to, so we have defined all the other parts. Remember, we use the word proposal and consideration, promise and consideration. Promise led us to proposal. Now we have to define consideration. Okay, consideration is important to understand. We'll have some cases on consideration also. This is an important point to understand. Consideration is essentially, think of it as any kind of, you can read the actual definition. These are all taken from the Act, by the way. Okay, I have just arranged it in a different way. Okay, I've just arranged the clauses in a different way, which to me seemed more logical. Okay, that consideration is anything that you think of it in broad terms as any kind of detriment. Okay, so if I'm taking out 50 rupees from my pocket and paying for a coffee, I'm suffering a detriment because now my wallet is lighter by 50 rupees. Okay, so I'm less wealthy now to the extent of 50 rupees. Okay, but and from the other side, that guy is giving me a coffee, so his coffee and his water and all that, his stock of all that has gone down. Okay, his sugar and everything, his milk and all gone down. So he's parting with something. So you can think of it in broad terms as detriment. Okay, you understand the word detriment? Detriment means some loss or damage or you know, we think of it in broadly in terms of loss, not in the contract sense, mainly in terms of loss. Okay, I have lost something. Okay, so even if I have to go and sit somewhere and like the security guard who's standing there, he's not really paying any money or anything, but his time is being spent, his attention, energy is being spent. So all that kind of detriment, okay, he's losing all that because he's losing the opportunity to do something else with that time. Okay, so maybe our alarm has let us down once again. Let's check it. Alarm has again let us down. But okay, now you just okay. I haven't taken much time. So the alarm business is not working. We'll take Gulati's suggestion, and I will appoint somebody at the beginning of the class as timekeeper. See, now it has come. That's the rooster. Okay. So this clock is a little slow. No, it's not slow actually. Okay, guys, we can go now. Hopefully the rooster has woken you up now. You can go and enjoy your break. Okay. All right.